Hello everyone, this is Tom Fox and I'd like to welcome you to episode 188 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all compliance solutions. I'd like to remind you about my upcoming FCPA Masterclass, which will be held in Houston, Texas, September 10th and 11th. It will be an intensive 2-day training on the nuts and bolts of FCPA compliance. I can safely say to you that there is no other class quite like it in the United States, and I hope you will attend. My slots are filling up, so if you have any questions, you can contact me at tfox@tfoxlaw.com or take a look at my Advanced Compliance Solutions website where you can register for it. Today's episode, I look at lessons learned from the Bank of New York Mellon FCPA enforcement action. This is a very significant enforcement action, so I take a deep dive into the case. The episode comes in at just under 20 minutes. I hope you will find it useful. Thank you for listening. Hello everyone, this is Tom Fox and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. As I indicated in my introduction, I'm going to take a deep dive today into the Bank of New York Mellon FCPA enforcement action, which was settled this week. It was settled via a agreed cease and desist order with the Securities and Exchange Commission. The case has several very interesting factors. It's a first in one area of enforcement. It certainly answers one question in another area of enforcement. And the order itself gives a number of facts which present significant lessons learned for the Chief Compliance Officer or the compliance practitioner, which you can incorporate into your compliance program going forward. So with that, the background facts are that Mellon hired two sons and a nephew from two officials of foreign sovereign wealth funds as summer interns or interns. The first question is, or first issue was, is a foreign sovereign wealth fund covered under the FCPA? I would have said 100% of the time yes. The SEC has confirmed this. This is not a court proceeding or with a judicial proceeding rather. So to the extent you want to try to attack that or defend that position in court that it's not, good luck. I don't think it's any doubt that a foreign sovereign wealth fund is going to be covered by the FCPA either as a foreign government agency or an instrumentality thereof. But the case involved hiring of these close family members. I think many compliance practitioners are aware of the J.P. Morgan sons and daughters hiring scandal in China that made public about 18 months ago. It's been extensively reported in the Wall Street Journal and New York Times. But this was the first enforcement action. We know that Credit Suisse, Goldman Sachs, Morgan Stanley, Citigroup, and UBS are all under investigation for the SEC for their hiring practices around the sons and daughters of foreign government officials. But Mellon's the first to reach a resolution on this case. So it's important for many, many ways. And the question had been whether the conferring of a benefit on a close family member, such as a son and daughter, was indeed a benefit to a foreign government official. And if so, how would you tie the obtaining or retaining business prong under the FCPA back? Well, unfortunately for Mellon, it was pretty clear that that was what was going on here. I should note this is not a Department of Justice criminal enforcement action. It is a Securities and Exchange Commission civil action. So we don't have evidences of bribes being paid. These are violations of the accounting provisions, books and records, and internal controls. But nevertheless, the actions of Mellon do prove instructive. Unfortunately for Mellon, as I said, it's pretty clear that these three interns were hired so that they would either keep the business they had with these sovereign wealth funds or garner new business. And the business was the sovereign wealth funds would deposit money into Mellon, and then Mellon would make investments with that money or use it in some other way. But clearly that's what Mellon was trying to get, was more investments from the sovereign wealth fund, and they did so through this hiring program of interns, and they certainly retained business. The fine and penalty was also interesting because a total of 14.8 was paid, and that consisted of 8.3 million for profit disgorgement, a fine of 5 million, and a prejudgment interest assessment of 1.5 million. The cease and desist order in it, Mellon specifically acknowledged that the SEC was not imposing a civil penalty in excess of 5 million based upon its cooperation with the Commission during the pendency of the investigation. So once again, we have clear evidence of the benefit you receive when you cooperate with the SEC during an investigation, as opposed to some of the other examples. Weatherford obviously comes to mind, who early on in its investigation did not cooperate with the Department of Justice or SEC. But there are clear benefits, and both parties acknowledge these in the cease and desist order. But the also interesting is that the profit disgorgement was above the civil penalty. Clearly, the SEC's ability to obtain disgorged profits is an important part of their mandate, and something to be not discounted going forward when you're making your risk assessments. Also, the facts of this case, I think, point directly to the tying of the hiring of the 3 interns and then the the foreign government officials. First of all, the customer or client relations managers were the people who made the decisions on hiring these 3 interns. It wasn't the HR department, and indeed their regular procedures were not followed in this case. But there was evidence in the cease and desist order that pretty clearly, in Mellon's mind, the hiring of these 3 interns was tied directly to obtaining or retaining business. So one one relationship manager was stated as saying, quoted as saying, "We are not in a position to reject the request from a commercial point of view, even though it was a personal request." He went on to state that by not allowing the internships to take place, we are potentially jeopardizing our mandate with the sovereign wealth fund involved. The foreign official actually made the request of the customer relationship manager, and that's obviously a red flag in any situation. If you have your foreign official recommending or asking that a certain person be hired, a subcontractor be hired, a company be used, directing business through a subcontract, it's all pretty clearly a red flag, and that's a pretty big one here. A second statement really tied it all together when it said that, once again, this is a Mellon employee, "I want more money for this." That's the quid pro quo. "I expect more for this. We're doing the official a favor." Yet another employee was quoted as saying, a Mellon employee, "I'm working on an expensive favor for a foreign government official, an internship for his son and his cousin." And then finally, in a statement I found to be perhaps the most interesting, even more than tying the business relationship together or the business deal to the delivery of the internship, was a statement around the lack of transparency. Everyone's gifts and business courtesy, and indeed entertainment or travel policy, one of the key components is transparency. Can you give someone, a foreign government official, a gift in front of his coworkers? Can you do it in front of his superiors? Do they know about it? Should they know about it? Well, here we had a statement that said, once again from a Mellon employee, "We have to be careful about this. This is more of a personal request. The official does not want his employer to know about this." So pretty clearly red flags flying all through this, and not cleared up at all. Regarding the second foreign government official, one of the emails said that granting this official's request was likely to influence future decisions taken within the sovereign wealth fund. Further, if Mellon Bank did not hire the son, it could well lose market share to a competitor as a result. Another Mellon employee wrote, "It is silly little things like this that help influence who ends up with the assets and retaining dominant position." And finally, one official conceded that it was the only way to increase business share. So all of these facts, and they're very bad facts, point to the fact that Mellon understood that these internships had value and they were delivering something of value, even if it wasn't cash across the border to a foreign government official. But the result was the same, that the foreign government officials involved either didn't pull money from Mellon, or they indeed sometimes affirmatively sent more money to Mellon and allowed their funds to grow. So the facts were pretty bad on the tying of the internship program to the obtaining or retaining business. But there were more bad facts that really lead to some pretty significant lessons learned. The first was the hiring process itself. These internships were prestigious internships that Mellon created so that it could evaluate candidates for potential full-time hires. If you went through a summer internship program at a law firm, you understand what I'm talking about. You come in over the summer and you're evaluated as a potential permanent hire. This makes this a pretty valuable thing to have because it gives you a leg up on everyone else who's so desperately trying to get that job because you've been observed and your work product seen. And Mellon recruited at high academics supported schools in the United States and the United Kingdom, which was they even described as prestige schools, or an exclusive group of universities in the United States and the United Kingdom. The successful applicants had to achieve a minimum grade point average, had to advance through multiple rounds of interviews, in addition to having relevant prior work experience and a demonstrated affinity for and interest in the financial services work. Additionally, they were graded on their leadership qualities. And unfortunately, none of those factors were taken into account when these 3 internships were presented to the sons and nephew of these foreign government officials. They didn't attend the universities. They didn't have the academic credentials to meet the requirements. They did not have any prior work experience or affinity for work in the financial services area, or indeed any indicia around leadership. And probably most damning is they were hired sight unseen with no interviews. They hadn't even been met by Mellon officials. So it was noted that Mellon decided to hire the interns before even meeting or interviewing them. So that's a pretty damning statement about going around or not using your standard hiring practice when you don't even interview or even meet a potential hire before you do so. But the problems Mellon had didn't stop even with the hiring practices, because the internships themselves conferred a benefit, and they were designed to confer a benefit. When I started this podcast, I talked about summer internships, and that's what these programs were. Summer internships for graduate students and those in undergraduate. However, these were not summer internships. They were 6-month internships. And the summer internships were designed, as I said, to present the candidates to Mellon employees for evaluation. But Mellon designed bespoke internship programs for these 3 interns. They received customized work experience, which were not available to regular undergraduate or graduate summer internships. They were really just customized one-of-a-kind training programs. These internships were valuable work experience, and the requesting officials derived significant personal value in being able to confer these benefits on family members. So you see the benefit, how the government official having the benefit and being able to confer that benefit down the chain to a family member was a benefit to that government official, further tying it to a FCPA violation. But more than the value of the internships themselves is the cost, because Bank of New York Mellon paid out money in non-monetary benefits in a manner different to its regular internship program. The bank determined because the interns had already graduated from college, they would receive more than the undergraduate interns. Also, the bank obtained visas for all three so they could travel from their home countries in the Middle East to work in the countries in which they were assigned. Mellon paid the legal fees and filing costs for these visas. They was part of this expensive favor that was granted for the foreign government official. And it was pretty clear that Mellon knew that internally this violated some internal policy, whether it be the code of conduct, the code of ethics, a conflict of interest policy, because they said we have to be careful about this. This is a personal request. And once again, that the government official involved did not want his employer to know about it. So what are some of the lessons learned under this case? Well, the first thing is, and I really want to emphasize this, there is nothing in the FCPA which says you cannot hire a close family member of a foreign government official. So let me repeat that because I think it's so important. There is nothing in the FCPA which says you cannot hire a close family member, son or daughter, a nephew, niece, brother-in-law of a foreign government official. But the key is, did they go through the regular process? And the start there is, did they merit the position? Because if they didn't merit the position, you have to have had another reason for hiring them. Think about your third-party management, risk management program. What's the business justification? If you're hiring someone and they don't have the merit for the position, what's the business justification? Can you articulate a business justification? Has that business justification been reviewed by the compliance function? Has the business justification had a second set of eyes put on it in terms of oversight? So if someone does not merit the position for which you're interviewing them, that really may be a full stop, and you should not go forward. Putting it another way, if you're hiring a family member or a close relative of a foreign government official for a reason other than merit, it better be a darn good one, and it better be well documented as to your business justification and decision-making calculus with appropriate management oversight, senior management oversight. But your program, your risk management of this issue does not simply stop with the hiring process. You need to look at who made the request to hire this person. Once again, in the Mellon case, we had the foreign government officials at the sovereign wealth funds themselves who made the request. So that's a red flag which needs to be cleared. But does that foreign official have decision-making authority over your business? Well, pretty clearly in Mellon they did. And finally, what's the work going to be for this son or daughter or close family member? Are they going to be working under a contract which was sent to your company by the foreign government official? If you recall the J.P. Morgan Sons and Daughters case, there was an alleged spreadsheet which tied contracts to specific hires. But this is a little bit different. Is the person you are hiring going to work under a contract sent by their father or mother or other family member? So you need to think about where is that person going to fit in your organization? And then once again, looking at the Mellon case, are you giving them a special job which you've had to create because they really weren't merited to hire in a regular position? It all speaks to, if an exception was granted, why was the exception granted? Has it been justified in writing? Has that justification been tested by one or two sets of eyes above in the process? All of that means you need to have a set of internal controls going forward. You can't have customer relationship managers making calls on hiring, which override your regular HR process. HR's got to be part of the process, but they have to have mechanisms for identifying red flags, sending that to compliance, and then having compliance involved in the FCPA issues involved. So you can hire a family member of a foreign government official, but you need to understand that it's high risk, and because it's high risk, you need to manage it more closely. So these management steps I've given you in terms of lessons learned, they do apply to a wide variety of other high-risk issues under the FCPA. Obviously, third-party risk management comes to mind. But you can do this. You just have to have them go through the regular hiring process, have all of your steps documented, put a compliance analysis on it, and then put a second set of eyes on it from your compliance committee. As I indicated, this is the first of probably several hiring cases under the FCPA. It really cuts some new ground in terms of what is a benefit that can be delivered to a foreign government official. It's answered the question of whether a sovereign wealth fund is covered by the FCPA. So I'd urge you to take a look at this case. I've written extensively on it over the past few days, so you can check out my blog, which is tfox at or tfoxlaw.wordpress.com, the FCPA Compliance and Ethics blog. I hope you've enjoyed this podcast, and I look forward to visiting with you in the future. Thank you for listening. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have 2 calls to action for you. If you have any questions about this episode or any others, I hope you will send me an email because I am putting together my next mailbag episode for my podcast. The second thing is, if you are listening to this on iTunes, if you can go to iTunes and rate this podcast, I would appreciate it. Once again, thank you for listening, and I look forward to visiting with you on upcoming episodes. Thank you very much.